For the record, please.
Juan Martinez on behalf of the state.
Clerk Attorney Jennifer Wilmot on behalf of Jodi Arias.
Good afternoon, Your Honor. David Bodney, and with me Chris Meeser on behalf of Phoenix Newspapers, Inc. and KPNX Broadcasting Company.
Good afternoon. I received your application this morning. The attorneys also have received a copy of your application. What is the state's position with regard to the application?
I'll leave it to the court's discretion.
Mr. Nurmi.
Judge, I have reviewed the application. I would cite the court as we had in previous proceedings. As to Estes v. Texas, there is a right to a public trial, but it must be weighed against the rights to have a fair trial. And given that, we believe that the rights, the things that are discussed in those chambers and at bench conferences, etc., help facilitate her receiving a fair trial, and the dissemination of said material would interfere with that. I believe that the attorneys for Phoenix Newspaper have not put forth anything that really would demonstrate to the contrary. Having spoken first, I'm not sure which assertions they would make. However, it has been their consistent position, I guess, or to seemingly ignore the fact that this is a death penalty case. More process is due than less, citing the court to Lockett v. Ohio, 408 U.S. 586, and Woodson v. North Carolina, 428 U.S. 280. So we have not only an instance where we're talking about fair trial, but we're also talking about fundamental fairness in sentencing in a death penalty setting. That fundamental fairness as it relates to trial and sentencing is eviscerated if crucial information that must be discussed amongst attorneys and the court is somehow publicized. That would, again, interfere with her right to a fair trial. The benefit to the right to the fair trial is really held by Ms. Arias, not by Phoenix Newspapers. This is a trial, not a television event. Citing to Garnett Company versus De Pasquale, 443 U.S. 368. With that, Judge, I would rest. I think I've made sufficient record of my position. And again, I would continue to cite the reality that the Phoenix Newspapers have not provided you any serious authority as to why in these proceedings Ms. Arias' rights should be truncated by their desire to have these transcripts.
Mr. Bodney, do you have anything you'd like to add to your written pleading?
Thank you, Your Honor, for this opportunity to be heard. We appreciate it. We are certainly mindful that this is an important criminal case, and we do not mean to take up any more of the court's time or attention than necessary, and we do not mean to diminish the importance of the Sixth Amendment and fair trial rights in this case. But since Estes versus Texas was decided in the 1960s, the United States Supreme Court decided no less than 4 cases in the 1980s recognizing a First Amendment right of the press and public to attend criminal proceedings. Important cases just like these. And so we're at a decided disadvantage when it comes to offering specifics as to why the hearing that took place on February 20 or any other closed proceeding in this case should be open. All we can underscore in assistance to the court, quite frankly, on this issue is this. there is a First Amendment right of the press and public to attend virtually all aspects of criminal proceedings. That is a presumed right, and it can be limited only upon a showing buttressed by specific findings on the record of some overriding interest that trumps that First Amendment right, and a showing that the narrowly tailored provisions designed to protect that interest are essential to preserving a higher value. And finally, that there really are no less drastic alternatives to closure. And so, because we don't know what was said in any closed proceeding, we have to repose our confidence in the court to issue specific findings on the record, either in support of closure or in support of release of transcripts of any proceedings that have been closed to date. And I recognize that, as the Ninth Circuit Court of Appeals recognized in what we call the Symington case, the Phoenix Newspapers versus District Court decision, that release of those transcripts should occur when any danger dissipates. So if counsel for the defendant is aware of some danger that would exist to the fair trial right of his client by release of a sentence or two or the entirety of that February 20 transcript, and the court agrees, then I suppose findings in support of that conclusion should be issued, and then the press and public will have a greater understanding about why that particular hearing took place in closed session and why any other hearings in this important criminal trial take place in closed session. So in closing, Your Honor, we are very mindful of the importance of the case from the prosecutor's perspective and from the defendant's perspective. We are mindful of Your Honor's time, and for that reason, I will conclude my remarks unless there are any questions. Again, we appreciate the opportunity to be heard and to ask the court to give life to these First Amendment protections, which our Supreme Court of the United States has recognized.
Thank you, Mr. Bodney. This court is mindful of its obligation to keep the courtroom doors open. We have done so in this trial. This trial has been covered by the media gavel to gavel. Some of the evidentiary rulings in this case have been held in open court. Others have not. When this court closed a proceeding, this court made findings consistent with Rule 122 and Arizona law. Specifically, this court found that there does exist a compelling interest that overcomes the right of the public to access the record of that particular proceeding. The court has also found that there is a compelling interest supporting sealing or redacting the record when it was required. Specifically, this court found on occasion that the privacy interest of witnesses, possible witnesses, and jurors could be affected by the disclosure of certain matters that occurred in chambers. The court also found that a substantial probability exists that the compelling interest will be prejudiced if the record is not sealed until this trial is concluded. The court also found that that proposed sealing was narrowly tailored and that no less restrictive means exist to achieve that compelling interest. The court also found that dissemination of materials and information that was exchanged during the in-chambers proceedings would affect the defendant's right to a fair trial because of the intense media scrutiny in this case. Dissemination of certain matters discussed in those in-chambers proceedings could affect the strategy and the evidence presented in this case and could affect the testimony of potential witnesses. For those reasons, the court has chosen to seal certain portions of this case certainly nothing that was heard by the jury, but certain evidentiary matters and other hearings. So the application for leave to intervene for the limited purpose of unsealing the transcript of February 20, 2013 is denied for the reasons stated. Some of the in-chambers proceedings were not sealed, and if there is a specific hearing or a specific request, this court will consider that. But I believe that most of the in-chambers proceedings were sealed at the request of the defendant, and there was no objection from the state. And as I said earlier, this court made specific findings that sealing those specific proceedings was necessary and in the public interest. So, is there anything else, counsel?
No.
Your Honor, just the only matter not related to this simply deals with exhibits. Since we are beginning to redirect, my understanding is the counsel for the state still has one exhibit checked out. We'd like the opportunity to have that returned so we can check it out in preparation.
Mr. Martinez?
And he discussed it with me 5 minutes ago, asking whether or not I had another exhibit. I indicated to him that I did. I would return it tomorrow, so I'm not sure why that's becoming an issue.
I want to make a record of it.
Counsel approach, please. Indicated you had something else to say.
Thank you, Your Honor. Very briefly, just 2 points of clarification. I thought I heard Your Honor say that the application was denied for the reasons stated. I would hope that the application for leave to intervene, based on the standing that my clients enjoy, would be granted, but that the relief requested today be denied, recognizing that we have a standing request for copies of those transcripts at the conclusion of the trial or whenever the reasons for their closure dissipate, if sooner.
All right, I will grant your request to intervene, and I believe it would be appropriate for those transcripts to be made public after the trial has concluded. So if that clarifies my ruling?
It does, Your Honor. Thank you.
I would take issue with that if there is a death sentence imposed, there is an automatic appeal, there's automatic post-conviction, there's many habeas issues that could arise. I don't think an automatic unsealing dissipates any issues related to those possible proceedings if the sentence is death. So I would take issue with the court going that far at this point in time.
All right. I will give defense counsel an opportunity to indicate any specific proceedings that you are concerned about, and this court will take up the request of the intervener at the conclusion of the trial and make a determination of which proceedings should remain sealed and which may be provided.
I would then ask for, if at the end of this trial, Phoenix Newspapers is making such requests, that they file specific requests with me in advance so we can take it up, so I can take a look back at what these things are.
Yes, most of them would require a transcript, I think, from a court reporter because those proceedings were not conducted in the courtroom, so there would not be an FTR record. We would need a record from a specific court reporter. So, Mr. Bodney, if you had a specific request for a hearing on a specific date, you would need to give us enough time to have a transcript prepared so that we can all review that and make a determination.
And Your Honor, I guess we would like to make a standing request for the February 20 hearing, and if there have been other closed proceedings at which issues in this trial have been decided, we would request access to them. Obviously, we don't know what was said during those closed proceedings and therefore can't be any more specific than that.
All right, Mr. Babbitt is the court reporter for that particular hearing. I will request that he prepare a transcript so that all the parties can review that specific proceeding. Is that the only one you're concerned about now?
It's the only one I'm specifically aware of now, though I understand there to have been others.
All right, I can't tell you when that transcript will be ready. He has many requests for transcripts, and it will be in line with all of his other requests. But I will pass that along. All right.
Appreciate that. Thank you,
All
Your
right.
Honor.